All rise, please. The United States District Court for the Western District of Washington is now in session. The Honorable James L. Robart presiding.
Please be seated. The clerk will call this matter.
Case number C-12-1282, DOJ versus City of Seattle. Counsel, please make your appearances for the record.
Mike Diaz for the United States.
Christina Fox for the United States.
Jeffrey Murray for the United States.
Peter Holmes for the City of Seattle.
Mark Filippini for the City of Seattle.
Andrew Meyerberg for the City of Seattle.
Ian Warner for the City of Seattle.
Hillary McClure for the Seattle Police Officers Guild. Lisa Dugard, co-chair of the Community Police Commission, Pro Se.
Thank you. Council, we are here for a status conference in this matter. It was requested by the City of Seattle, and you can find that request in the docket at 335. In response to a request from the court, I have reviewed material from the City of Seattle. And when I say material, it was a brief and an attachment with a number of documents. A brief from the United States, an amicus brief from the Community Police Commission, and a memorandum from the Seattle Police Officers Guild. And I have had an opportunity to review all of those and found them helpful. For today's hearing, I have allocated 20 minutes to the city, to the United States, to the CPC, and to Seattle Police Officers Guild, which sometimes will get referred to undoubtedly as SPOG. I further directed the city to extend the invitation to the Seattle Police Management Association. And there was filed today a letter to Mr. Meyerberg from the attorney for the Seattle Police Management Association that I think speaks for itself. It says, and I quote, "I am in receipt of your recent letters regarding the upcoming status conference for Judge Robart. As you are aware, SPMA is not a party to this litigation. For this reason, we do not intend to either attend the status conference or to submit any briefing to the court at this time." Signed by their attorney. There has also been a request to the court from the King County Labor Council to address the court. I'm going to respectfully decline that request. This is a court proceeding which involves parties and admitted amicus and invited groups that have a direct stake. I would respectfully suggest that it's not a public hearing, which I think would be more appropriate for the Labor Council's remarks. So, with that said, I'll hear from the city first, and you have approximately 20 minutes, Mr. Holmes.
Good morning, Your Honor. May it please the court, I'm Pete Holmes, City Attorney for Defendant City of Seattle. As the court is aware, this stage of our 4.5-year police reform effort has focused on the city's permanent police accountability structure. We have labored to explore all aspects of accountability systems, both tried and true, as well as new ideas regarding best practices, and presented a structure we deem to be the best starting point for Seattle. And this was submitted to the court in October for the court's review. The mayor, Your Honor, is now ready to submit his proposed legislation to City Council and commence our legislative process to further refine these accountability ideas with the court's guidance. And throughout, the executive has simultaneously negotiated in good faith with the Seattle Police Management Association and the Seattle Police Officers Guild. Now, should police officers' bargained wages, hours, and conditions of employment ever cause police services to conflict with the Bill of Rights to the United States Constitution, I'm confident that no one in this room would say that the Constitution must give way. But it is often difficult to link any term of a collective bargaining agreement to a pattern or practice of unconstitutional policing. And as this court noted at our last status conference, the case law addressing such situations is quite sparse. Now, the wiser course under the circumstances would be simply to not call the question. And that has been the city's approach, to simultaneously tackle police reform as monitored by this court and keep our police unions fully informed partners, because we believe that together we will all emerge from this process better in what we accomplish together, or we will fail to the extent that we fail to cooperate. Unfortunately, SPMA has decided to call the question. Just weeks after the city's proposed accountability legislation was filed with the court, SPMA filed an unfair labor practice complaint with the State Public Employees Relations Commission, seeking to restore the status quo. In other words, to reverse all police accountability work completed since May of 2016, including the legislation, Your Honor, now under consideration. So what are the implications of SPMA's ULP on Seattle's federally mandated police reform? I'd like to approach this question, Your Honor, three basic perspectives. First, I want to comment on the other positions that were expressed in the other written briefs that were filed by year-end. It's probably a good thing that I'm going first, Your Honor, this morning, because the city and I are fairly alone in the briefing that was submitted. Second, I will review the actual impact of these parallel PERC proceedings on the city, whether or not the city prevails in defending against the ULP allegations. And on this point, Your Honor, I'd like to briefly introduce, again, Mr. Mark Filippini from K&L Gates, who can be my backup to the extent we get down into the weeds of PERC procedure. And then lastly, Your Honor, I want to discuss some possible measures that this court might take to help protect our reform progress to date and ensure that its eventual successful completion, assuming that SPMA doesn't first dismiss its ULP and come back to the bargaining table. The first brief that we need to address is the one that we didn't receive. And where is SPMA? SPOG does not speak for SPMA, and SPOG has no insights and offers none into the reasons for and the objectives of SPMA's unfair labor practices complaint. And although SPOG has previously joined forces with SPMA, when the two organizations wrote to this court on August 9, 2016, and then more than 3 years earlier when they sued this court's monitor along with the city together to challenge the authority of this court in the consent decree. In spite of all that, the city has continued to negotiate in good faith, and it is reassuring to know from SPOG's latest submission that it doesn't feel that the city is bargaining in bad faith, that we are not, as others have said, trying to cram the consent decree down the throat of the unions. But we must accept SPMA's ULP allegations at face value, that it is seeking to undo at least all of the city's work on a permanent accountability system since May of 2016. Now, the plaintiff, United States, and the CPC Amici brief, their briefs, frankly, are not helpful. And the reason that they are not is because they appear to assume that the city need only engage in what is in effect effects bargaining, that it's not real substantive decisional bargaining, quid pro quo bargaining. But this, Your Honor, this ULP is a direct run at the court's admission that the city must not be forced to pay for constitutional policing. Unions simply do not file a ULP to protect a process. They do so to exact decisional bargaining, to receive something in exchange for the substance of the matter that's under deliberation. Now, unfortunately, unlike every other advocate the court will hear from today, my office must not only defend against the ULP, I have to advise my mayor and my city council on best courses of action. And the only prudent legal advice I can give is that anything they do from this point forward with no change in the ULP that's pending could conceivably be undone just years down the road after an expensive and time-consuming litigation before PERC. In other words, we will still probably have to come back to this court, Your Honor. We must make no mistake that SPMA's ULP presents an immediate harm to the city and its reform efforts. PERC has accepted SPMA's amended complaint in its preliminary ruling, and under that agency's normal process, we must present documents and evidence and witnesses in an evidentiary hearing to prove our defenses to the ULP charge. These might include, for instance, proof that the city's management prerogative in police reform is more significant than lieutenants and captains' interest in an unchanged work environment. Or we might assert a business necessity defense. To prove either defense, however, the city would have to establish the need for these specific reform measures through documentary and live witness testimony. It could include SPD command staff, representatives from the mayor's office, community members, and other key witnesses who may be beyond the city's reach, including the court's own monitor, even the court itself. The hearing itself would be needlessly expensive and disruptive, further delaying the reform process. And it would require a state agency to evaluate the importance and necessity of acts undertaken by the city under supervision of this court. So finally, Your Honor, what does the city recommend, given that we don't even have SPMA here in court to provide feedback, and assuming it doesn't change course and return to the bargaining table? We have, Your Honor, I assure the court, reviewed all possible options, including removal of the PERC proceedings, the possibility of injunctive relief, and whether it's this circuit's case law for removal or the Norris-LaGuardia Act at both the federal and the state levels, those options do not lend themselves to this situation. The city doesn't feel it's appropriate to compel its own unions to join in litigation, and it has not sought to do so. And at the same time, Your Honor, we have to acknowledge that the collateral attacks now being mounted in PERC threaten to undermine and delay the reforms we've achieved to date. The third parties, as we know, under the case law, and again, that August 9 letter cited case law to the court. On the one hand, while we can't unilaterally change bargaining rights and agreements, on the other hand, a third party can't simply stop a consent decree in its tracks simply by withholding its consent. I had suggested in the brief, Your Honor, we submitted that perhaps an order saying that the collateral attack itself would be res judicata, but there are also some other remedies that the court might consider, including one suggested by the unions themselves in their August 9 letter. They have offered to present to this court the areas where they believe their collective bargaining rights interfere with the court's jurisdiction. The court could allow a limited amount of time for that to happen. Again, the city is not seeking to join, either through joinder or nor would we oppose, however, a Rule 24 intervention by the unions. But we must recognize that under the current situation, that if we go forward, all of this work simultaneously litigating before PERC whether or not a ULP commenced as far back as May of 2016 and continuing through all of the subsequent measures directed by this court, that puts the city in an untenable situation. We believe that a floor for the bargaining terms, perhaps coupled with a timeline from the court by which the unions could assert their rights and bring their concerns to this court, could help us to move forward and continue with the progress that we've achieved over the last 4.5 years. Your Honor, unless there are any questions from the court, that concludes my remarks.
That's fine. Thank you. To Diaz.
May it please the Court, Your Honor. First, I'd like to briefly provide a little bit more context, a few more details about our argument in our brief and the path forward that we recommend. But we really want to leave the majority of our 20 minutes to answer any questions that Your Honor has for us. That's really where we want to be most helpful. Starting with our own argument, again, we focus on the document that governs this process, which is the consent decree itself. There are only two applicable provisions in this consent decree that touch on any type of conflict or challenge or tension with external processes. Those are paragraphs 226 and 227. The purpose behind 226, the reason we drafted, the reason Pete signed it, the reason our office signed it, the reason this court entered it, we think is to prioritize challenges and then wait for true challenges or conflicts with the consent decree to emerge. And then, when that happens, to channel those challenges back into federal court when it's ripe. That's the idea of each of those sentences in 226. What that means is that 226 was purposely not meant to touch on or address every policing topic that creates a theoretical tension with the consent decree. It wasn't meant to invoke the federal court in every single possible topic. It wasn't even meant to involve the federal court when an administrative process is commenced. 226 itself says when an administrative challenge occurs, the parties will notify each other. Only when there is a state or municipal court challenge will then the parties be obligated to remove that to federal court. And there, at that point, then many things can happen, and that's happened before. So here, under our reading of 226, it just doesn't apply. Now, the following paragraph, 227, addresses the specific situation when there is a tension between a collective bargaining right and the consent decree. And again, like 226, not every facet of the consent decree that implicates collective bargaining rights rises to the level of needing federal court involvement. Not every facet of the consent decree, even adjudicated to be a mandatory subject to collective bargaining, rises to the level of needing federal court involvement, at least in the first instance. There is a ripeness concept inherent in 227 that hasn't been met. And the reason why we think it's not ripe is because there are several what we call off-ramps. There are ways the administrative process can resolve without the need for federal court involvement. And we don't pretend to be experts. I'm glad Mr. Filippini is here. I'm glad other folks are here who know a lot more about state bargaining process. But it's our understanding that SPMA has to convince PERC that the topics raised through accountability legislation or whatever else after May 2016 are quote-unquote mandatory subjects of bargaining, A, and that the bargaining didn't actually occur. Those are two things if they can't prove that, those are two off-ramps to this administrative process. If they do, then under 227, again, the parties are obligated to work in good faith to accomplish the goals of topic X of the consent decree through alternate means. And then it should only be of interest to this court if those alternate means either require modification of the consent decree, in which case we would come back to you, Your Honor, and say, we've identified an actual true term of mandatory subject of bargaining, and it requires modification of the consent decree, and we're asking you to modify your court order. Or we are unable to reach a resolution of that issue. And then, in that case, as we mentioned in our brief, paragraph 225, under 225, we would come to you and say, Your Honor, we have a dispute. We need help resolving this. And then we would, either way, it's going to come back through this court, is the bottom line, if necessary. For us, though, when we read SPMA's complaint, and again, we're not experts, and we're not pretending to be experts, but when we read it, it sure seems like they are most concerned about bargaining occurring before implementation. And as both SPOG and the CPC's briefs point out, that is clear within the legislation itself, that this is going to happen. Mr. Holmes mentioned that some negotiations have already happened, so we don't see even getting past that first off-ramp of bargaining not happening before implementation, which is the first hurdle that they would have to cross. And it's for these reasons, then, that, again, just to summarize, we hope that Your Honor permits the process that was well thought out, that was long in coming, to go forward on legislation. Let the PERC process play out over the next several months as well. And so let's see if either 226 or 227 ripens. The benefits of that is it protects the city's interest in seeing, because the city has an interest, of course it has an interest, in seeing the legislation move forward expeditiously. There are a lot of folks watching this legislation go forward. There are a lot of folks within the city government who want to see that go forward expeditiously. It protects that. It protects the union's interest in assessing whether anyone violated their rights to collective bargaining of mandatory subjects. And it protects the consent decree. So for all those reasons, we think keep on keeping on is probably the best way to resolve this issue. And with that, Your Honor, I'm here to answer any questions that you might have about our position.
I believe I understand the government's position, so thank you.
Okay. Thank you, Your Honor.
Morning, Your Honor. If it pleases the court, I'm Hillary McClure here for the Seattle Police Officers Guild. As you noted, we will probably refer to them as SPOG, or I may even say the Guild. Collective bargaining is a process, and the process itself is important. The process is how unions get to provide input. It's how the parties get to discuss ideas and come up with new ideas, better ideas, and it's the way that the parties get to move forward and implement the ideas that they've brought to the table. The process itself, the Guild believes, is very important. And it's a process that the city has committed to for implementing any changes to mandatory subjects of bargaining that are implicated as a result of the city's settlement agreement with the Department of Justice. You've heard the city attorney mention a lawsuit that was filed several years ago. The history of that lawsuit needs a little bit more information for you, I believe. What SPOG sought there was a clarification. And what we wanted to understand was the legal obligations of the city related to the settlement agreement. And the city answered that question for us. That's why we dismissed the lawsuit. If you look at the order in that lawsuit, that's exactly what the order is premised upon, is that we reached a TA with the city, and it was because of the TA that the tentative agreement, with the city, and it's because of that tentative agreement that we dismissed that lawsuit. And what that tentative agreement committed was that to the extent implementation of the agreements entered into by the city with the United States Department of Justice to include settlement agreement, MOU, and monitoring plans, implicate changes to mandatory subjects of bargaining, the city and the Guild agree to engage in collective bargaining over the proposed changes.
Counsel, if you want a record, you need to slow down.
Sorry.
It happens when people start reading.
I apologize. Let me start over on the reading then. To the extent implementation of the agreements entered into by the city with the United States Department of Justice to include settlement agreement, MOU, and monitoring plans, implicate changes to mandatory subjects of bargaining, the city and the Guild agree to engage in collective bargaining over the proposed changes and reopen the collective bargaining agreement to effectuate such bargaining. That's an agreement that the city entered into with the Guild after it had already entered into the agreement with the Department of Justice. And it's one where we felt the city was answering that question for us of what it believed its legal obligations was. And for that reason, we dismissed the suit. SPOG has relied on the city's assertions that it will comply with the bargaining process for years. And that goes back to this agreement that was back in August of 2013. And we hope that the city will continue to honor its commitment to the bargaining process. Within the accountability legislation, we believe that the city has proposed a way to honor its commitment to the bargaining process. That is the language that the terms do not become effective with regard to any provision that's subject to bargaining until that bargaining has occurred. That is why we believe that as the city has explained the process to us, that they will be able to bargain in good faith with us. They have explained the process to us that it is before you now, that they will then go to the city council and get more information. And once they have all of that information, they will come to the bargaining table and they will bargain with us in good faith. And we need to allow the parties to have the opportunity to do that. Although I don't believe it was specifically touched on to the extent that it was in the city's brief, the city has requested that the court issue an order declaring any collateral attack on the consent decree by SPMA or SPOG as barred. As you'll notice, SPOG you're being asked to conclude SPOG in that matter, despite the fact that this is an unfair labor practice that was brought by SPMA. The city is characterizing the filing of an unfair labor practice as a collateral attack. And so in essence, what it appears the city attorney is asking for to us is that the court issue an order prohibiting SPOG or SPMA from filing any unfair labor practice. We believe this is problematic for a number of reasons. The city is mischaracterizing that an unfair labor practice requesting the enforcement of a bargaining process is a collateral attack. As the DOJ has pointed out, unfair labor practice over the city's procedural failure to bargain is not an attack on the settlement agreement that's been entered into by the city and the Department of Justice. We believe that this request is in direct contradiction to the assurances and commitments that the city has made on numerous occasions over the past several years to bargain in good faith under RCW 4156. Because part of the bargaining process in that RCW is the enforcement process. The bargaining process defines what is an unfair labor practice. And so by asking the court to issue a broad order like that, the city is actually asking the court to void the agreements that it's made, to void the past contracts that it's entered into with SPOG, where it assures SPOG that it will collectively bargain over changes to mandatory subjects of bargaining. In the same way, that request is in direct contradiction with the draft proposed accountability legislation, where the city is committed that any provision of the ordinance shall not become effective until the city satisfies its collective bargaining obligations. The city is then, with its request for the order that it has from the court, turned around and asked the court to preemptively prohibit SPOG and SPMA from seeking any enforcement from PERC if the city does fail to bargain. The city should be honoring its agreements, including the provisions of the settlement agreement with the Department of Justice, where it addresses the collective bargaining process, and not asking the court to allow it a different method to end around the process that was set forth from the beginning. The city also brings up in its brief that it believes that SPOG has waived its rights. To just address that, what SPOG has done is relied on the commitments that were provided to us by the city. The city has always told us that they will bargain with us in good faith. We have taken them at their word, and we have believed them. And now, all we want is the opportunity to let them comply with that, to sit down with them at the table, to see the proposals that they bring to us, and to bargain in good faith with them over those proposals. We don't think it's appropriate that the city should be asking the court to use our reliance on their commitment to bargain with us against us. The particular issue here is about the accountability legislation, and as I noted in our brief, the legislation allows for collective bargaining, and we just want the opportunity to have that process have a chance to occur. We agree with the DOJ that the issues before you, we don't believe are even ripe yet. We haven't even had the chance to allow the process to occur before the city has attempted to stop the process.
All right. Thank you, counsel. Mr. Gard.
Good morning, Judge Robart. I want to start by acknowledging that I'm joined in court today by co-chair Harriet Walden, and I would be remiss in not noting that today is her birthday. Several other commissioners currently seated on the Community Police Commission and our staff. We are quite sympathetic to the complex situation that the City of Seattle and its sub-entities find itself in, given the complexity of parallel proceedings. And we are quite supportive generally of the collective bargaining rights of unions. But what brings us into court and our only interest in this proceeding is to secure effective accountability reform. And it is with an eye to that objective that we wanted to caution against or recommend against this court taking any action at this juncture that would alter or compromise the procedural rights of the labor unions under state law at this time. The first reason is that to take the city's justification for seeking some sort of order from this court is to prevent delay. But we are concerned that taking such a step at this time could actually cause delay and introduce an element of uncertainty into our road forward toward accountability reform that we really cannot afford. The reason for this fundamentally is that the labor organizations are not in this case. They are not parties, and for this court to take steps that would in some fashion cut off their access to procedural remedies and to effectuate important rights that I'm sure most people in this court, maybe everybody in this court generally supports under state labor law, takes us into really perilous, uncharted waters and introduces the specter of delay and later challenge. If we do not believe that in order to move this reform process forward or the settlement agreement process forward, the city needs to compromise the collective bargaining rights of its unions. And it has always been on our understanding that that was also the city's view. But if that is untrue, if the city does need to alter the collective bargaining rights of its unions in order to discharge its obligations to this court, there is a procedural mechanism for that, and that is to move to join the unions as parties under mandatory joinder provisions. That is the mechanism that would apply if those circumstances obtained, which again we do not believe that they do. But no such motion has been made to this point. I understand that the city has its reasons for not having made such a motion, but not having made that motion to then seek action from this court that would compromise the procedural rights of those labor organizations introduces an element of uncertainty and frailty into the foundation of what happens henceforth in this proceeding that we don't believe is wise or necessary. I also think it's difficult to discuss this matter because of the uncertainty as to exactly what the city is requesting from the court. We don't have a draft proposed order. I think if we did, maybe this discussion would be easier to focus. But in the city's pleading, there was a suggestion that this court should at this juncture enter an order that precluded SPMA and notably SPOG from accessing avenues that they would otherwise have access to in order to protect rights that they have under state law. And again, an order to whom precluding what? SPOG has, there's no suggestion that anything that SPOG has done amounts to a collateral attack on what is going on in this proceeding. I think it is important to take a careful look at SPMA's unfair labor practice complaint, the revised complaint that's presently before PERC. It discusses the proposed accountability legislation, that is true. But the remedy that that complaint requests from PERC is not to forestall that process. It is, I would suggest, a fair reading, and obviously they're not here and we're not speaking for them, and we're not privy to their thinking. But on its face, a fair reading of that complaint is that the non-involvement of SPMA, the city is not involving SPMA in the process leading up to the submission of the accountability legislation to this court, is just an illustrative example of a more global failure to engage in bargain, which is the gravamen of the SPMA complaint to PERC. And to the extent that we're right about that SPMA's complaint is broader, it is really far outside, it touches on matters that do not intersect with the proceedings in this court. And it may represent SPMA seeking to vindicate procedural rights that have very little to do with events in this case. And, you know, the CPC doesn't have an opinion on, and we are not well informed enough to form an opinion on, even if it were within our scope of work, the merits of that SPMA global assertion that the city is refusing to bargain toward a comprehensive agreement. That is in their revised complaint the way that they framed it. It is they are concerned about failure to make progress toward a comprehensive agreement that they have not had since 2011. If where I'm wrong about that, and if the ULP complaint by SPMA does challenge the accountability legislation process that this court is supervising, we agree with the United States that there are ample, targeted procedural mechanisms available to this court should the city fail to defend that process before PERC. Most fundamentally, however, we believe that the city can and will prevail in defending that process before PERC because it is not an unfair labor practice. SPOG has greatly assisted this court in filing a brief and a declaration from its president, Kevin Stuckey, an original member of the Community Police Commission, attesting to SPOG's expectation that its collective bargaining rights under state law will be fully vindicated by the city as laid out in that package of proposed accountability legislation. The council can take it up when the court gives the green light. The mayor can move it forward. The council can act on it. If the council acts in ways that the court has not seen, this can be brought back to the court. And before then, components of that legislation that carry with them the obligation to engage in, and I do want to say decisional bargaining, not just effects bargaining, decisional bargaining. Before those would go into effect, it's fully contemplated that decisional bargaining would take place. SPOG has greatly assisted all of us by filing a brief saying that they are satisfied with that process. We need to take yes for an answer. If at all possible, if achieving police reform and vindicating the collective bargaining rights of labor unions can be reconciled and harmonized, we should attempt to achieve that. For the procedural justice values that are both important to police reform and, as we argued in our brief, very important to achieving the legitimacy of that reform with employees of a police department. We have the CPC from the very beginning, as Your Honor well knows, and I'm sure is tired of being reminded, the CPC was charged originally with taking a look at the accountability system and making recommendations for possible change. The settlement agreement itself barely touches on accountability. There are, in a couple of places, measures that have intersected, and we fully understand why the court has taken supervision of the process. But as Your Honor has repeatedly stated, it is not the court's intention to mandate the substantive content of these reforms. The court is overseeing a process that allows for the city to change its accountability system, which in the original DOJ investigation was found to be basically sound and strong, to make improvements that it sees fit for the court to ensure that those do not violate the spirit or the letter of the settlement agreement. Since we began that work back in 2013, we have openly and often discussed that we wanted to do the work, we intended to do the work in a way that did not run afoul of the collective bargaining process. We finished our recommendations in the spring of 2014. By April, that was significant because we understood that bargaining was to commence with SPOG shortly thereafter, and we wanted not to put the city in the position of arguably engaging in an unfair labor practice of having commenced bargaining and then dealing with us on outside of that process to come up with the values that it would seek to achieve in that bargaining process. Everyone knew this. It was often discussed with the mayor's office, with council representatives, with the city attorney's office, with the unions themselves, and with the United States. The city, I think SPOG's brief and Mr. Stuckey's declaration fairly reflects all of the conversations that we've had formally and informally with the city for the last 3 years. The city has manifested in every respect a full intention to discharge its collective bargaining obligations to its unions with respect to this accountability legislation, and has worked hard, even when it's been complicated and has taken a lot of time, to harmonize that commitment with the approach that this court laid out. We would not have participated in a process of proposing accountability reforms that touched on areas that we well know are mandatory subjects of bargaining under state law. There's no question about that. Which exact subjects, one can argue about, but there's no doubt that some of the features of the proposed reforms that we've recommended are mandatory subjects of bargaining. And it has never been thought or suggested that those were going to be rammed down anybody's throat without bargaining. I think, again, that it's important that we all take SPOG's yes for an answer. SPOG has acknowledged that the route that Your Honor laid out accomplishes that harmonizing of a process interior to the settlement agreement, and then honoring the bargaining obligations with the labor organizations. Should PERC not see it that way, the settlement agreement not only permits, but we would argue probably requires the city to remove that enforcement action to this court, and Your Honor can then take the steps that the city, we believe, prematurely is recommending today. Unless the court has any questions, that concludes our remarks.
Thank you.
Thank you.
The reform process we've been discussing today, from the court's point of view, began in 2012, when what has collectively become known as the consent decree was signed. The progress since that time has been in a number of areas. I would include among them use of force, crisis stops and detentions, bias-free policing, and supervision. Major changes have been made by the Seattle Police Department under the enlightened leadership of Chief O'Toole and her staff, assisted by Mr. Bob and his staff as the federal court monitor. We are not going to be going back. Recently, the focus of the litigation and the monitoring process has focused on the Office of Professional Accountability, as it was known, and currently is known, and police accountability for excessive force, bias-free policing, investigation of police conduct, and the police disciplinary process. That's only a small part of the consent decree, but it obviously touches a nerve, as these are very serious subjects, and they are the subject of a national debate which is taking place right now, caused by regrettable circumstances. Not surprisingly, the attention focused on this area of accountability has brought representatives of what I would characterize as the old guard to protest that they are not opposed to reform, they just want to bargain about it. The City of Seattle has asked the court, and I quote, "Defendant City of Seattle consequently requests an order from the court declaring any collateral attack on the consent decree by SPMA or SPOG as barred, including SPMA's '(S) collateral attack on the consent decree by filing its ULP complaint with PERC." End quote. The court is mindful of its obligation to respect existing contracts and does not intend to interfere with the collective bargaining process which it supports. The court believes, however, that upholding civil rights does not involve automatically curtailing collective bargaining rights, which is a yes or no, 0 or 1 analysis that I don't think is applicable here. So let me first start by saying something that I said earlier in a prior court hearing. The court will not allow the people of Seattle constitutionally guaranteed rights to bias-free policing and to be free from excessive force to be held hostage by the collective bargaining process. Ultimately, the Constitution trumps a contract which contains provisions which violate those constitutional rights to bias-free policing and to be free from excessive force. This is not a situation unique to Seattle. Little did I know that since 2012, I would have the opportunity to read the clash over police union contracts and reform efforts that at least have taken place in Newark, Albuquerque, Portland, the Virgin Islands, Los Angeles, Pittsburgh, and most recently Baltimore and Chicago. That takes me then to where are we today, and I'd like to remind parties of the following. First, what is the status of the legislative package? The city has submitted a proposed legislative package to the court. The court will issue an order on that in the immediate future, in keeping with the time frame that we set last fall. Following that, and it may require some changes to the proposal, I expect submission of a legislative proposal to the City Council and City Council action on it. That will then trigger further review by this court, and I am hopeful completion of this phase of the consent decree. Nothing in that process has to interfere with the collective bargaining rights of the unions, as long as the provisions are consistent with constitutionally guaranteed rights. That also takes me to the question of termination of the consent decree. This is the start of 2017. The consent decree was adopted, as I mentioned earlier, in July 2012. Paragraph, I believe it is 229 of the consent decree, actually the settlement agreement, provides that it will be completed, or it is contemplated that it will be completed in 5 years. The actual process of, or processes that are contemplated in the settlement agreement and in the memorandum of understanding were really fully implemented by early 2013. And if I apply that 5-year target, that would say that by 2018, the Seattle Police Department will be free of me, the city will be free of me, And there follows a 2-year period of review to ensure full and effective compliance. I'm not willing to speculate about much that's going to happen in 2020, so I'll leave my comments at that. The court sees a light at the end of the tunnel. If this is, and I quote, reaching full and effective compliance, end quote, or an approaching attempt at derailing the consent decree remains to be seen. It is my intention, however, that we will continue to move forward with reform efforts, and I look forward to both the completion of the reform efforts and the review process. As part of that, I look forward to full implementation of the court's oft-repeated endorsement of body cameras. So, what do I do with the city's current request? The court is constrained by 3 considerations. First, as noted by the United States, paragraphs 226 and 227 of the settlement agreement address exactly the situation that we contemplate now. 226 provides the parties agree to defend the provisions of the settlement agreement. The parties will notify each other of any court or administrative challenge to the settlement agreement. I believe that's happened. In the event any provision of the settlement agreement is challenged in any state, county, or municipal court, removal to a federal court will be sought by the parties. That's the complete language of 226. 227 provides the city and Seattle Police Department agree to promptly notify Department of Justice if any term of the settlement agreement becomes subject to a collective. I believe that's been done. Department of Justice agrees to work in good faith to accomplish the goals through alternative means, if necessary. That's one of the 3 considerations that constrains me, because that is the basis of my ability to act to fully implement the settlement agreement. Second consideration is jurisdiction over parties who are not present as parties in the litigation. That's a basic premise of federal law, that I don't have authority to just start ordering people who are not parties before me. And finally, the long-standing constitutional doctrine of a justiciable controversy, which the lawyers will all understand, and simply says, I got to know what I've got in front of me before I start mucking around in it. Based on these constraints, I find that the ULP complaint filed by SPMA does not satisfy the terms of the consent decree pertaining to judicial intervention or removal at this time. We don't know what is going to happen. Should the ULP process ripen, the parties in court retain the ability to resolve any challenge or conflict under the terms of the decree itself. I'm mindful, Mr. Holmes, that I put the city in a difficult position, but I am constrained by the 3 doctrines that I have mentioned. Lastly, I'll make one additional comment, and that has to do with the letter from SPMA and the general status of this litigation at the present time. I believe the court has that the Constitution of the United States ultimately controls the outcome of this litigation. Running, hiding, or sticking one's head in the sand from this fundamental truth does not advance the litigation or promote the laudable goals of the consent decree. My remarks will constitute the court. It will be reflected by a minute entry in the docket. Counsel, I found your submissions to be helpful, and I appreciate your cooperation today. We will be in recess. Thank you.
The court is in recess.